Welcome to our edition of Lunch and Learn for today. Chad Caffer, we always talk about having a great team, and Chad Caffer is one of those pillars on that team to make sure that our clients are well taken care of, especially in the legal world. So with no further ado, Chad is going to talk about the land of entitlements and development process. Chad?
Thanks, Mike.
Yep,
Appreciate it. As Mike said, my name is Chad Caffer. I'm with the law firm of Davidson & Caffer. Davidson & Caffer has been in the Valley for 26 years. We practice primarily in the areas of business and real estate law. We've done everything from set up real estate brokerages, set up mortgage brokerages. We've represented title companies and developers. We are a little different from a lot of other law firms in that most law firms have transactional departments and have departments that handle litigation. We tend to have all of our attorneys handle both transactional matters and litigation. Our belief is if you've never put a deal together, you don't know how to defend a deal when it falls apart in court, and if you've never seen one fall apart in court, you don't know how to properly protect your clients when you're putting a deal together to know what the pitfalls are. Today we're going to talk a little bit about entitlements. Entitlement law is kind of a misnomer, and the phrase we've given is land of entitlements for this one. Entitlements are legal rights conveyed by approvals from governmental entities to develop a property for a certain use, intensity, building type, or building placement. Now, a lot of people think that when it comes to entitlements, what you have are a group of rights that you get with respect to your property. That's not really the case. The word entitlement actually comes from English law, and essentially what they're talking about is you're asking for the approval, the right, or the entitlement to do something on your property. You're going to a governmental entity, a city, for instance, a city planning department, and asking for the right to develop a piece of property. And that's essentially why we say you are not entitled to entitlements. To give a little bit of background, the way that the courts or attorneys look at property rights isn't the way that most lay people do. We look at property rights as a bundle of rights. So by illustration, let's say for instance you own your home and you think this home is mine, I own 100% of it, I can do with it what I want. In reality, if you were for instance to sell your home, the only way that you can do that if you have a mortgage is to pay off that mortgage, meaning that your lien holder, the person who lent to you in order to be able to purchase the home, has some right in your property. They have a right to receive the proceeds from the sale. If you want to just dig anywhere on your property, you actually can't do that because some parties have certain rights with respect to the property, for instance, to run power lines or to run sewer lines. So you have to leave those undisturbed even though the property we typically would say is technically ours. Those parties also have rights within the property. And that's really what we're talking about. So when it comes to property that you purchase in a development sense, normally what you're looking for is what's the plan, who has some sort of vested right with regard to this property, and how do we negotiate that right? So for instance, typically when you're looking at parcels, they might be pre-platted in a certain way, they might have existing easements. That's certainly the case in Arizona. A little bit of history, when Arizona was a territory, it was divided up into sections by what the Bureau of Land Management essentially became a successor of. But essentially the federal government divided Arizona into sections. There are section lines that are reserved for highways, for utilities, for ingress and egress, that sort of stuff. So basically what you're doing is you're talking about how to negotiate that type of process. So we'll talk about the entitlement flow chart. And some of this information is taken from the city of Scottsdale because that's the body that I'm most familiar with, but we certainly deal with development work throughout the Arizona Valley and throughout Arizona for that matter. So the entitlement flow chart starts with the pre-application, essentially an initial meeting and a discussion about what's needed for the project that you're planning to undergo. An application and actual entitlement or public hearing process, meaning you'll make a formal application with a lot of give and take and a lot of changes to that application over time and stipulations until finally you actually have a public hearing in front of a public body, normally either a developmental review board or the planning commission. C, plan review and permitting, which is actually the review of what it is that you're attempting to do, and a final permit to do what it is that you want to do. Inspections, there's a process for that, so as you're building or developing, there is an inspection process where someone comes out to look at the progress of the work and to sign off on it. And finally, a certificate of occupancy, essentially saying, all right, this project is done and it's available for the public to occupy. Now this process that we're going to be talking about is very generalized. There are lots of changes or nuances that can happen depending on the project that you have, but we're going to talk in just a general sense about what happens, best case scenario, if you're going to develop some property. Here are the players when we're talking about development. First, we've got a project coordinator. The project coordinator typically, and again, this is based somewhat off of experience, but this can change from municipality to municipality. The project coordinator will handle pre-application submittals and ensuring delivery of all requested documents. So the basic idea, and we'll talk about this in more detail, is you go before a project coordinator and you say, hey, this is what I'm trying to do. They'll give you a document that says, these are the sorts of things that you need to submit to us in order for us to even consider your application. And that project coordinator will then essentially check off the boxes to make sure all of those materials have been submitted. You have city staff. City staff handles the review of those submittals and makes recommendations as to what needs to be done based off of the use that you're requiring in the property and the plan for that property by the city. The Development Review Board. The Development Review Board normally deals with layout, site planning, the relationship of the development to the surrounding area and the community. Now, the important thing to remember with the Development Review Board is they are only involved with respect to commercial uses. So that would include obviously commercial properties where you have retail stores and things like that, but they also consider a commercial use if you're going to be developing a subdivision. So if you're subdividing lots and putting homes on those lots. And finally, the Planning Commission. The Planning Commission deals with zoning requests, general plan amendments, use permits, abandonments, municipal uses, that sort of thing. There are certainly other bodies that you could find yourself in front of. These are just the ones that we're dealing with for right now. There's the City Council, for instance. If you do something that's a drastic deviation or seeking something that's a drastic deviation from the general plan for how a city's already been planned out, you might have to go in front of City Council, which is actually pretty common. Let's say, for instance, you purchase a lot that has a use that's going to be different than what was intended for that lot. You might go in front of the Board of Adjustment. For instance, we had a client who needed to get a variance for an encroachment on their lot. And essentially we're saying, we came to this encroachment when we purchased the lot. There was no way to fix this. Can you just give us a variance? You'd go in front of the Board of Adjustment typically for that. So the pre-application process, what does it look like? This is essentially planning and outreach. So the first step is the pre-application request, and we talked about that. The pre-application request is essentially a form. Just about any municipality is going to have this. It's a form where you check off boxes and say, this is what I intend to do. You will typically go in, set a meeting, which is an immediate meeting. You just pull a number and go and sit down with your project coordinator. Tell them what you're attempting to do. Normally they'll look up the property. They'll tell you what uses are on that property, and we'll tell you things that you might need. For instance, let's say that you have a utilities easement on the property and you're attempting to move where that utilities easement is going to be. They might tell you, well, one of the things you're going to have to do is to get that utilities approval in order to do that. If they know that, for instance, there's a protected area on that property with respect to a particular, environmentally protected animal, a desert tortoise, for instance, they might tell you you're going to have to get an environmental study. You're going to have to submit that. Once you've gotten your checklist essentially from the project coordinator, you know what you have to do and you start putting those things together. After you've put your application together, we're now in the pre-application meeting. This is the meeting with the project coordinator to discuss the size, scope, and feasibility of the project. So you've got everything together, and essentially what you're doing is you're saying, okay, this is what I want to do, is this feasible? And they'll give you some feedback on that. You can make adjustments accordingly. The last step is city staff review. This is just for the pre-application process. So city staff, essentially what they'll do is they'll look at the application and they're looking at it from the perspective of what the developmental review board might want, what city council might want, what, for instance, what impact you might have with regard to schools, drainage, environmental concerns, all of those sorts of things. And then we'll come back and we'll say, well, here are stipulations to your project that we'd like to have honored. Here are things, additional information that we need. So that's essentially the pre-application process. Now the application process. The application process is the one that most people are familiar with. It ultimately leads to a public hearing that you've probably seen in front of, for instance, the planning commission or heard of in front of city council. The first step is completing the application checklist and requirements. So you've made a pre-application. There's now a request to make a formal application to whatever municipality it is. You check off your boxes, you put all the materials together, and you hand it to city staff. Now, those materials could be a variety of things. It could be engineering reports, could be drainage reports, could be platting, that sort of stuff. Step 2 is the review. So city staff then reviews the application and takes a look to see whether or not it's complete, and they'll issue a letter back to you saying, these are the sorts of stipulations we have, this is the sort of additional information that we need from you. Step 3, you have what they'll call the first review. So staff reviews the application, they issue their comment letter, and they'll tell you what needs to be resolved before you can have a public hearing date. Now it's important to note, anytime that you make one of these sorts of changes with regard to development, you're eventually going to have to deal with the public. One of the suggestions we always have as a firm is to get that process starting quickly. Let people know what you're doing, reach out to the public before just giving a notice to the public of what it is you're going to do with neighboring property, because those people will show up at meetings, promise. The fourth is applicant revision submittals. So essentially you're going to get your letter with stipulations saying these are the sorts of things you need to do in order for us to submit this for final approval. So you will make your revisions, submit back the revisions, and then go back through the process. Step 5 is the revision review by the city staff. So in essence, they'll look to see whether or not you did what they asked you to do, and whether or not there are additional changes or additional stipulations that need to be made. And finally is the public hearing process. So what will happen is a date will be set, and if you've ever seen on a corner, there's, you might see a big billboard that's either orange or green that has a lot of information and a hearing date. That's essentially what that is. It's letting people know this is the date and this is who the hearing will be in front of. It could be in front of the Developmental Review Board, it could be in front of City Council, it could be in front of the Planning Commission, depending on what the project entails. Here's the plan review and permitting stage. So let's assume that you've gotten your final review. The first thing that you'll have is a building plan review. And this is going to be different depending on what it is that you're doing. If you're buying a commercial project, for instance, and rehabbing the commercial project, there might be much less information that needs to happen than if you're doing a ground-up build. So you'll have a building plan review, an engineering plan review, and these are not necessarily in any type of time order. Most of this stuff happens at the same time. Fire and safety plan review and the planning plan review, and finally permitting. So the idea is you're going to compile all of these different reports. We'll have architectural, if you're actually doing construction, aside from just subdividing the land. You'll have engineering reports that talk about drainage and how utilities get to the property. You'll have something that says here's where the roads are going to go, here's what we do in terms of fire safety, here's how fire trucks or safety vehicles get in and out. And then finally, provided you meet all those requirements, you ultimately get to a permitting stage. Once we're at the permitting stage, that's when we start doing our development. And again, this assumes a little bit that what you're doing as a developer is actually purchasing for the purposes of construction. It's not uncommon for developers to purchase land, subdivide the land, and then sell off portions or the entire project once the entitlements have been had. But with respect to some of our clients, a lot of them like to actually finish out the project. If you are finishing out the project, the first stage would be foundation inspections. So if you're doing single-family residences in a subdivision, for instance, you have foundations that get poured. You'll have the inspector come out, take a look at the foundations first, and you're done until you get that final inspection. Under slab and floor inspections, and after that, masonry inspections, roof deck strap and shear walls. Finally, a framing inspection, insulation inspection. And then this is the one that most people get caught up on, gypsum inspection, which is essentially just drywall. Essentially what you call it a gypsum inspection, but really what they're doing is they want to make sure that the utilities you put in a home or in a building are put where they're supposed to be and they're done correctly before you close up the walls. As soon as the walls are closed up, then you put on your drywall, and after that happens, we go to final inspection. So the final inspection, and once you've had your final inspection, you get a certificate of occupancy. That's the final stage in the development process. Everybody's, I'm assuming, pretty familiar with the term C of O. Certificate of occupancy just means that the public can now occupy the property, whether it's a home or it's a public space. There's also the right to get a temporary C of O. This happens a lot more in commercial projects. The idea is you've done all the work you need to do. You might have a deadline, for instance, if you're a tenant doing TIs, and you say, I need to be in this property right now. I've done everything. All that we're waiting for is the final. Can I have people in the property? And typically, most cities will allow you to do that, provided you post a small bond. And that is pretty much the end of it. That's the development review process. Does anyone have any questions? All right.
Okay,
Thanks so
thank you,
much.
Chad. Appreciate your time.